really excited to introduce our speaker today, Madeline Howard. Wish she could be with us in person, but we are really lucky to have her by Zoom. Madeline is Senior Staff Attorney at Western Center on Law and Poverty, where she focuses on fair housing litigation, unlawful detainer appeals, and issues impacting tenants in foreclosed homes. Before joining Western Center in 2013, Madeline was a senior staff attorney with Bay Area Legal Aid in San Jose and San Francisco, where she represented interests of low-income tenants against landlords and major lending institutions. At Western Center, Madeline partners with legal services attorneys on impact litigation to challenge discriminatory housing practices and preserve affordable housing. And she also supports direct services attorneys through technical assistance and training on issues ranging from unlawful detainer appeals to fair housing rights. She received her law degree from Berkeley after working as an advocate at Medical Legal Partnership in Boston, which I also want to hear about some other day. And that was the nation's first medical legal collaborative. She went on to become a research attorney at San Francisco Superior Court before returning to direct services work. We are really lucky to have her, and I am going to turn it over to Madeline now.
Okay, thank you so much, Stephanie. Thank you for inviting me here today, and thank you to the Bar Association for hosting this. Hopefully I'll be able to operate the tech correctly. I am also sorry that I can't be there in person. I was really looking forward to seeing everyone. So let me see if I can get this to work. Okay. All right, can everyone see my PowerPoint here?
Yeah, we can see it.
All right, sorry, it's just looking very different than it did when I did this before, and there we go. Okay. Okay, so what are we going to talk about today? So when we first planned this training, the Tenant Protection Act felt like sort of the most exciting thing happening in housing. And now we're in COVID land, so everything is very different. This feels like sort of old news at this point. But the Tenant Protection Act is a very complicated law that establishes just cause protections for tenants and rent caps. And I'm hoping that I can spend the next hour and a bit more maybe explaining it to you, kind of breaking it down because it's very complicated. So let's get started. Before I do that, I want to tell you a little bit about Western Center on Law and Poverty. So we are a backup center for legal services programs. So programs like Stephanie's that provide services for low-income folks, we are the backup. So if there is a case that needs to become a class action, when there are complicated appeals, when there's a need for legislation to be passed, we get involved in those types of cases. I work on housing, obviously, but we also do work in areas of healthcare and financial security, including like things like food stamps and also fines and fees. And then we also have kind of an overlay of racial justice on everything that we do. So that's more about Western Center. I also want to hear about who's here today. And I want to learn more about this audience so I can kind of make my remarks more relevant. Could you please launch the polls that we have for the audience? Okay, so please let us know a little bit more about your experience with this new law and about your background generally. Okay, just give you a few more seconds to answer this. Thanks, everyone. Okay, so thank you, Nicole. So it looks like many people are a little bit familiar with AB 1482, but maybe not experts yet. And then a wide range of experience. Lots of folks have been practicing for a long time. And we have some real estate attorneys with us. Okay, this is really helpful. Thanks, everyone. Okay, so let's close out of that. Okay, so Before we kind of jump in more to 1482, I want to give a little bit of an overview of all of the different landlord-tenant laws that went into effect on January 1st of this year, because there was a really busy year in the legislature for landlord-tenant stuff. So in addition to 1482, there's also AB 1110, which provides for a longer notice period for large rent increases. And it's kind of funny because AB 1482 says that in most cases you can't get a big increase of rent over 10%, but in those houses that are not covered by AB 1482, tenants are now entitled to longer notice. AB 1399 closed an Ellis Act loophole. I'm not going to go into that too much. That's a whole rabbit hole. SB 329, this is another bill that we sponsored at Western Center. This new law says that people who are using a Section 8 voucher, a voucher that goes with the tenant, those folks cannot be subject to discrimination. So that means that you cannot say in your advertisement for housing, no Section 8. And if someone wants to use a Section 8 voucher or when they rent their home, you can't say, I don't accept those. So really important change in the law there. And SB 222, sort of in a related way, also says that you can't discriminate against people who are using VASH vouchers, which are specifically for veterans. SB 18, I know I'm going very fast, just want to kind of flag these issues. SB 18 extends tenant protections for people living in foreclosed properties. Hopefully, with the current situation, we are not going back into another housing crisis, but it's looking pretty scary right now. So this may become more relevant than we want it to be. But these protections were passed originally during the foreclosure crisis in 2008, 2009, but they had a sunset on them. So this bill just removes that sunset. And that gives tenants in foreclosed properties extended notice, the right to stay through the end of their lease, and things like that. SB 330, this is a huge bill, and I just want to flag that it does include some tenant relevant issues. When housing is going to be demolished, for example, it includes some protections saying that people have to be provided replacement housing. And then at the end of today, I'm going to go into this a little bit more, but FEHA, there are more regulations that explain what our state fair housing law means. So I'll talk about that in more detail later. But this is just sort of the big picture, a lot of things happening in Sacramento on landlord-tenant this year. Okay, so our focus today is on AB 1482. It looks like some of you are somewhat familiar, so you probably know this overview, but for those who are not. The two main things it does are establish rent caps, so limiting the amount that rent can be increased, and just cause protection, so saying you can't be evicted for no reason. There are a lot of exemptions, and I'm going to talk about those. But it also provides that people who are evicted from their home for no fault of their own, say for example, the landlord wants to move into the house, then those tenants are going to get relocation assistance under this bill. And it also has multiple notice provisions saying tenants need to get notice of their rights in various circumstances. Okay, so a little bit more about the bill. It's codified in a confusing way because it was originally two separate bills that were sort of squished together. And so the just cause provisions and the rent cap provisions are codified separately at 1946.2 and 1947.12 of the Civil Code. And it creates a little bit of confusions because the exemptions are not exactly parallel. So I just recommend whatever case you're dealing with, if you're looking at whether this law applies, you just need to look at the code. I mean, I have read this thing like 100 times and I still just have to read it again and again and again. Both sections of the law say that a waiver of rights is void. So you can't say, tenant, just sign this thing so you don't get the protections of just cause or so I can raise your rent more. And it also specifically references Civil Code 1632, which is a language access protection. So if other parts of the tenancy have been negotiated in another language, like in Spanish, then any of the notices that are required by this law also have to be provided in that language. And both laws, both sections of the law preserve more protective local laws. So places like San Francisco and Berkeley, who already had rent control, that is going to be preserved. And there is a sunset in the law of 2030. I want to take a minute to talk about Costa Hawkins because Costa Hawkins just causes a lot of confusion, I think. It was on the ballot, it's going to be on the ballot again probably. And I think a lot of people were sort of didn't understand how this law impacted Costa Hawkins. So 1482 does not repeal Costa Hawkins. That's like the first thing you should know. And what Costa Hawkins is it focuses on local rent protections. So Costa Hawkins says that you can't have a local ordinance that says rent control applies even if all the tenants leave and there's entirely new tenants coming in. So it limits that local authority. And it also limits the local authority to impose rent control on post 1995 or whatever the local date is. It says newer buildings have to be exempt. Then it also has limitations on these protections for condos and single family homes. But the thing to understand is that 1482 is a state law. So it doesn't have that, it doesn't have to deal with Costa Hawkins basically because it's a state law. It doesn't have to abide by those things. And so whereas local ordinances have this new construction exemption issue, 1482 can apply to newer buildings. And so what 1482 says is all of these protections will apply to buildings built more than 15 years ago. So it's a rolling date. So next year, you're counting back 15 years from 2021. So hopefully that answers a few questions about Costa Hawkins. I think this is just a difficult area. Okay, the exemptions. I have tried so many ways to simplify this visually, and it's just hard because the exemptions are confusing and they're not the same from the rent control to the just cause provision. So this is my effort. I apologize for all the text on this slide. There's so many words on here. As I mentioned, I think when you're dealing with a specific case, you just really need to look at the statute because there's just a lot in here. But I'll try to walk us through some of the sort of basics here. So some things I think are obvious. So hotels and hospitals and dorms, those types of housing, you wouldn't really be expected to have rent control apply, and they are exempt. As I mentioned, there's also this exemption for housing that was built in the last 15 years. So it's a rolling date, which is different from how Costa Hawkins operates on local rent control. Mobile homes are also exempt. So mobile home landlord-tenant law is like a whole separate section of the statute. It's like its own thing. So AB 1482 does not apply to mobile homes. Affordable housing. This is an area that's I spend a lot of time talking with people about. The wording of the statute leaves something to be desired. It's pretty confusing. But the sort of basic thing to know is that where there is a subsidy attached to the unit, like there's a deed that says this housing is restricted, this is only affordable housing, then that housing is going to be exempt from AB 1482. But if a tenant is using a voucher, like a Section 8 voucher, what you think of as a Section 8 voucher, where they sort of can go to any apartment they want to, that is not going to be exempt. So people who are using mobile Section 8 vouchers, they will be protected. Let's see, other things, single family homes. So single family homes, this has a whole subsection of the statute. And single family homes in some cases will be covered by AB 1482. For example, if there is a corporate owner, people have probably heard of like Blackstone Homes, these big corporations that buy up single family homes and then rent them out. So those types of housing will be covered. However, if there's a single family home being rented out to like an individual tenant, then that housing is going to be exempt. And there's a lot of iterations here. I get so many questions about this with these funky fact situations. So again, you just have to look at the language. But another sort of common scenario that comes up is when someone is renting out a single family home, sort of like it's a multifamily property, like they'll be renting individual bedrooms out to separate tenants. In that case, it is going to be covered by the law. So I know this is a lot. I just keep on having to look back at the statute whenever I'm looking at a particular case because it's just really complicated. So to help us walk through this, I did some quizzes. I hope this will keep you awake. I know everyone's on Zoom meetings all the time and it's very easy to sort of fall asleep. So wake up and do a quiz with me. So here's my little graphic of our single family home. Nicole, can you bring up the quiz for us? So we have Joe, and he is renting a room in a single family home. It's built in 1980, so we don't have to worry about that date. And there's 3 other tenants who separately rent rooms. So do we think that 1482 is going to apply to this situation? Thank you everybody for participating. Yeah, so we don't know the owner yet. As you can see from the slide, I have some more information that we'll add on. The answer is yes. So I'm going to kind of start going through this as we go down. But yes, it should apply because as I mentioned, when something is sort of functioning as multifamily housing, it doesn't matter who owns it because there's multiple tenancy there, it is going to apply. So yes, it will, even if the elderly couple is owning it. So not a corporation. Individual people owning the home, but it's functioning like multifamily housing with these multiple tenancies. So yes, it's still going to be covered even with the elderly couple owning it. And what if the owners live there too? This is kind of a trick question and your answers reflect that. We've got a half and half. So that can get confusing. If the owners live there too and they are sharing the bathroom and kitchen facility, then you are going to have an exemption apply. But for example, if they live in like an ADU in the back, an accessory dwelling unit in the back with separate facilities, then no. So that was a trick question. Thank you. Great job. You guys get A+ on your quiz. Okay. All right. Now I can get my. Okay, interactions with local laws. I'm not going to spend a long time on this part because I don't think it is going to impact your practice too much. But the idea with 1482 was that nobody wanted to mess with the laws that were already on the books. So Berkeley, San Francisco, Los Angeles, a lot of communities have very protective tenant ordinances already. And the idea of this state law was to leave those in place and only protect communities where there is no rent control existing. And I think I'm just going to leave it at that because I don't think this really is affecting a lot of people who are working in SLO. Okay, now we're going to dig in a little bit more to each of the separate sections. So we'll start with just cause. So again, what just cause means is that you need to have a reason to evict someone. If you lived in a community where there was no local protection, a landlord could just evict you for no reason. Even if you lived there for 30 years, you're the best tenant ever, you could still just be evicted for no reason. So just cause that this 1482 law applies to most properties, what it says is you can only be evicted for a good reason, whether it be because you did something wrong, like you didn't pay your rent, or because of something that wasn't your fault, but it's still a good reason. Like, for example, the building needs to be demolished because it's so unsafe, or because the landlord wants to move in themselves. So let's talk a little bit more about just cause. So the biggest limitation here is the timing. So just cause protections do not start kicking in until after someone has lived in their home for 12 months. So someone who has just moved into the house does not have that protection and they can still be given a no cause notice. Obviously, if there's a lease, that's different. But if someone is just like on a month-to-month tenancy, they just moved in, they can get a no cause notice. But after 12 months, they have this protection where you have to state a good reason to evict them. And the timing can get a little bit confusing. So if a new adult moves into the home, then that sort of resets the clock. And then you say, okay, have both tenants been there for 12 months? So it kind of starts again. But then once one tenant has been in the home for 24 months, then just cause applies and it doesn't keep resetting. So if you imagine a situation where maybe someone has a 2-bedroom and maybe a different adult is kind of moving into the 2nd bedroom after a while. If there's one sort of anchor tenant that stays the whole time, after they've been there for 24 months, then they have just cause and it doesn't go away. And anyone who met this time requirement as of January 1st of 2020, they are going to be protected. So again, let's kind of go through and see how this works with a quiz. Okay, so let's pull up the quiz and I can start reading it. So Jane moves into her unit in November of 2018, so we're going way back in time. And then her boyfriend Jamal moves in June 2019. So when does just cause kick in? Thank you. Good job. So I see lots of folks are voting for June 2020. Yeah, so in June 2020, both of them will have been there for 12 months. And so that is the correct answer. Great. Okay. Okay, so now they both met the 12-month requirement. And even if a new person moved in later, once Jane has been there for 24 months, she is going to be protected, and that protection stays with her. Okay, so we're going to go through the different parts of just cause. First, talking about at-fault just cause. And what at-fault just cause means is this is something where the tenant has done something wrong. It's sort of the usual way you would think about an eviction, like you didn't pay your rent, so I'm going to evict you. That's a standard reason. But under this protection, anyone who is covered by AB 1482, they can only be evicted for these specific reasons, not for any other reason. Some of them are pretty broad. And I'm not going to go through these in detail. Some of them are very obvious, non-payment being the most basic one. But something I want to highlight a few things here. I think the thing that sort of is the most different from how the law was before is subsection B. It says that you can be evicted for a material breach, like doing something that is a serious breach of the tenancy agreement, after a notice to correct. And that's the thing that's really different. So normally when someone breaches their lease, they do something that they're not allowed to do under the lease, they're doing something that's causing another tenant, like harassing another tenant or something like that, you can give a notice to cure or quit. So you say you either fix this problem or you have to move out. But now under this law, it's adding this additional notice. So now it's saying you first have to just get a notice that says cure this problem, fix this breach. And then only after the person has not fixed the problem during that notice period, only then can you get a notice that says you have to quit, you have to move out. So it's 2 steps of notice. And this is something that is very different from the current procedure, and it's also not contemplated by the current complaint form. So those of you who have done an unlawful detainer case before, you know that this is very form-based practice. So there's a form complaint that the judicial council puts out, there's a form answer, and the current one does not have this 2-step procedure. It doesn't have anything about AB 1482. But the judicial council put out proposed forms that will reflect this 2-step notice period and will reflect all of the parts of 1482 that we're talking about today. And that is scheduled to come out on September 1st of 2020. I know the Judicial Council has been very busy with dealing with COVID stuff, so I'm not sure if that date's actually going to happen, but that is the schedule. So that's just important for you all to know that right now the form complaint stuff does not reflect the law. And hopefully pretty soon we're going to have complaint forms and answer forms that do reflect the law. And this notice provision is quite different than how it works now. The other at-fault just cause things are pretty obvious. Some of them have some nuance to them. Just highlighting the criminal activity provision, it says that you can be evicted for at-fault just cause if you do criminal activity on the property, including the common area, and then says also something against the owner that's off the property. So it's pretty specific. And then, let's see, anything else to highlight here? I think the other of these, we could talk forever about these, but I think just flagging this is the list. This is the exclusive list of reasons that someone can be evicted. Okay, so here, I want to just highlight what the complaint form looks like now so you can kind of see how it works. So here in subsection 7 of the complaint form, it talks about what notice was served, and right now it doesn't say anything about this 2-step notice part. So just flagging that for you. Okay, so no fault just cause. So the other reason that someone can be evicted under this law, if they are covered, is even if they didn't do anything wrong, there are certain reasons that the landlord can still serve an eviction notice. And they are listed in 1946.2b. And they're here on the screen. So it's some things that you would expect. So if the owner wants to move in, if the tenant agrees in writing to allow that, withdrawal from the property from the rental market. So this is familiar also. And then the owner complying with a court order. So if, for example, there's some very serious habitability issue that the people have to move out, then that would be the legitimate basis for a notice. And, you know, obviously there's like a whole other area of law on this in terms of relocation that's from the Health and Safety Code. So if someone is living in bad conditions, they have rights to other types of remedies, but I'm just focusing now on the eviction part. And then these last two subsections, D and E, these are something that I've spent a lot of time talking to people about because I think that they can be used in a way that is not as the law intended. So substantially remodel, this is specified in the law. It goes into quite a bit of detail about what it means to substantially remodel the property. So you can't evict someone under this provision if you're just going to, you know, add some carpet or put up some drapes or fix the cabinets or something minor. It specifies that you can only use this type of substantially remodel notice where it's something that is a really serious repair. It specifies that you need a permit, that it might involve abatement of hazards, doing a plumbing or mechanical system, and it has to be something that reasonably could not be accomplished in a safe manner with the tenant in place and requires them to be gone for 30 days or more. And so when I've spoken with people who are advocating for tenants on this provision, I would encourage them to look up the permit. Is there a permit for the work that's allegedly happening? What is the permit for? Is it actually serious work? Because I think that this can be abused. So that's something to look at in detail. Okay, so we're gonna move on to talking about rent caps. So as I mentioned before, this law started out as two separate bills. One was on just cause and one was on rent cap. So now we're moving on to the rent cap section, which is codified at 1947.12. And what it does is it limits rent increases over a year-long period to 10% or 5% plus the consumer price index. The consumer price index part of the law is pretty confusing, and it is actually the subject of a cleanup bill right now. Cleanup bill meaning sort of a bill that doesn't do a whole lot besides fix little problems in previous legislation, because it's just confusing. So we're working with landlord groups and realtors groups on getting that language to be clearer, because it really benefits everyone for it to be clearer. But basically the consumer price index, you can look it up in the link here. Last year, I think for the area including SLO was 3.3%. So rent increases over a year were limited to 5 plus 3.3 or 8.3%. So that's still a really big increase. But we were seeing, before these laws passed, we were seeing increases of like 100%, 80%, just like massive increases. So it's still it's a meaningful protection. And when you're trying to figure out how to count the rent increase, you're looking at the lowest gross rent during a period. So sometimes that can get confusing because people sort of sign up for housing and have like a discounted rate or something. You're not counting discounts, you're counting sort of the base rent, the lowest version of the base rent. You can't get more than 2 increases over a 12-month period. And this part of the law looks back to March of 2019, so that's when you start counting. And so people who received large rent increases between March 2019 and January 1st of 2020, the landlord doesn't have to pay back the excess increase, but the rent would sort of reset to the limited rent on January 1st. So that's a little bit of confusing math that you would need to do. And as I mentioned before, if everyone moves out and there's an entirely new household, then you can reset it to market rent. And you're not allowed to sublet for more than the authorized rent, which is pretty obvious. Okay, this is a lot. I hope you're not falling asleep. If you are, let's wake up and do another quiz. Okay, so Mary's rent is $1,500 and her landlord gives her a rent increase notice in February 2019. So looking way back, February 2019 for $500. The bonus question is, when does this go into effect under the old law? Mary starts paying $2,000 a month for her landlord, and then what is going to happen to her on January 1st, 2020? So let's take a few minutes to do this. Only one person has done my math. No one said what yet. Thank you. I added that in case you just were very confused. Hopefully no one's too confused by this question. So remember, we're looking back to rent increases that go into effect as of March of 2019. Okay, great. So we have, people are all over the place here. So let's look at how this works. Okay, so the answer is that it's reset to 1624, the sort of most funky math version. So for the purposes of this question, we're assuming it's covered, because otherwise, why am I even asking this question? So this is a covered property, so we're trying to figure out what the rent cap is. And so in terms of measuring whether this is covered at all, when you get a rent increase that's a large rent increase for over 10% in February, you would need to get a 60-day notice under the old version of the notice law. So it wouldn't go into effect until April. So that means it is going to be covered by AB 1482. And then the way you're measuring that rent increase is 5% plus 3.3, and that works out to be 1624. And again, the landlord does not have to pay back the sort of overcharged rent back from 2019, but as of January 1st, the rent would be reset. Okay, so that was 1482 on high speed. I covered a lot of material very quickly, and I'm going to take a minute. I'm going to take questions at the end, but I want to spend a little bit of time before we go into questions telling you about the new fair housing regulations. These got much less attention than AB 1482, and they don't change the law. They explain what the law already was, but they have a lot of really important concepts in them, and there's a lot on landlord-tenant law that I think people are less familiar, even people who are kind of doing landlord-tenant law on a daily basis. So I'm going to talk about this for a little bit. So FEHA is Fair Employment and Housing Act. So that is our state fair housing law. People might be familiar with the Fair Housing Act, which is the federal law that was passed as part of the Fair Housing Act, excuse me, as part of the Civil Rights Acts. And that's, you know, HUD and all of that has now being rolled back by the Trump administration. But here in California, we have Fair Employment and Housing Act, which is our state law that says you can't discriminate against people in their housing. It is extremely broad. It is broader than the federal law. And it says that people can't be discriminated against for any of the protected classes like race, gender, having kids, gender identity, ethnicity, all kinds of things. And so what the new regulations do, that they came out on January 1st, 2020 as well, they just explain what the law means in a way that's really, really helpful because it's much more accessible. And it also provides examples. A lot of the subsections just list out, like, this is what would happen if this landlord and this tenant, this is how the law would apply in this particular situation. So it's really, really helpful. They do not cover all of the fair housing regulations, all of the fair housing law. The council that works on these regulations is still working on other parts of the law, but they do cover things like reasonable accommodations for people with disabilities. They cover criminal history, they cover land use, so there's a lot in there. And you can find them. I have the citation right here, and then there's a link to where they're on the Department of Fair Employment and Housing's website. Really useful regulations. I encourage people to check these out. So this is an overview of the things that are covered for people who are practicing in different areas. The financial assistance practices section that talks about banks and lenders and real estate practices. There's a whole section that's for realtors. And then land use discrimination is relevant for people who are working in government. And then disability, criminal history, and discriminatory effect. These apply broadly to everybody. So I'm just going to highlight a couple of the provisions that I think are particularly helpful for people who are doing landlord-tenant law today. So there's a lot on there that's about unlawful detainers specifically. For example, I just have these are citations to the regulations themselves. So retaliation for a fair housing related conduct is a defense in the unlawful detainer. So what that means is if someone is complaining, for example, say someone thinks that they are experiencing discrimination by their landlord and they file a complaint with the Department of Fair Employment and Housing alleging discrimination. If the landlord then turns around and seeks to evict them, then they could say, that's retaliation. This looks like retaliation. I made a complaint against you for discrimination and now you're trying to evict me. So this specifically says if you are trying to defend yourself in that eviction case, you can talk about retaliation for fair housing related conduct in the UD. So really helpful to be sort of specific about that, especially where lots of people in unlawful detainers are representing themselves. Section 12176 talks about reasonable accommodations. There is a lot in there. I'm going to talk about a couple of detailed parts there, but just generally, reasonable accommodations, this is the concept that someone with a disability is asking for an exception to a rule or a policy in order to allow them to use and enjoy their housing in the way that anyone else would use and enjoy their housing. So there are lots of examples of this. I think one thing that people think about a lot is animals. So for example, someone who is blind, using a dog to help them get around. So living in a place that doesn't allow dogs usually, and asking for an exception so that they can have their assistance dog in the unit. Similarly, emotional support animals, like someone who has a mental health disability, asking for an exception to a no pets policy so that they can have their assistance animal. So there are many different types of reasonable accommodations, but the general concept is that someone with a disability needs something different to enjoy their housing in the same way. Some of the things that it says about reasonable accommodations are you cannot require a specific form, and it doesn't have to be in writing. So if someone, even if they don't know the words reasonable accommodation, those are not magic words, and a tenant can just ask a landlord, I have this disability, so I need this to happen in my housing. And the landlord would still have to consider that even if they don't fill out a special form or say the magic words reasonable accommodation. And it also talks about how reasonable accommodations can be used as a defense in an unlawful detainer. And something that's really important that has come up in litigation a lot in cases that I've worked on is that someone can ask for a reasonable accommodation in an unlawful detainer at any time, including sometimes after the eviction has actually taken place. So I've had the experience of having an unlawful detainer judge say, well, we're already at trial stage now, you can't talk about reasonable accommodations anymore. And this specifies, no, that's not correct. This is, the time doesn't sort of end. There's no time limit on when you can ask for a reasonable accommodation. So this can be really helpful for people who are working with tenants. A few other things that maybe would not be quite as obvious as sort of asking for the ability to have a dog in your apartment. There's a whole subsection talking about financial accommodations for people with disabilities, and it has some really helpful examples. These include waiving guest fees or other types of fees. For example, if someone did want to have their dog and there's usually a pet fee, if that dog is there as a reasonable accommodation, then it's not acceptable to charge a fee. Providing additional time to pay for cleanup. For example, sometimes a disability might manifest in someone having a hoarding and cluttering issue in their apartment, and giving someone more time to sort of clean that up and meet any relevant building codes. And using a cosigner. There's actually a case on this from the Ninth Circuit, using a cosigner when someone has a limited income because of disability. So maybe they don't meet the regular income limits for the apartment, but with a cosigner, they would be okay. Even if cosigners are not usually allowed, it would be appropriate to allow someone to use a cosigner as a reasonable accommodation. And then Article 18 of the regulations talks all about assistance animals. There's lots in there. Again, many examples and explanations and sort of talking about the difference between someone using an assistance animal versus a support animal. So just really helpful information for landlords and tenants. Okay, the last section I want to talk about on the fair housing regulations, and I guess I've talked so fast that I have plenty of time for questions, so that's good news. Criminal records. So this is an issue that people who are doing landlord-tenant law may be familiar that HUD, the Federal Department of Housing and Urban Development, they put out guidance on criminal records a few years ago, and talking about how a landlord having a policy related to criminal records that bars people from housing based on criminal records, it may be a Fair Housing Act violation because of the disparate impact on people of color. So specifically, if you look at statistics about who has a criminal record, Black and Latino people are more likely to have a criminal record than others. And so a policy that says nobody with a criminal record can live here would have a disparate impact. It would have a greater impact on those populations. And because of that, it would be a fair housing violation. So just like in the federal law, we have this disparate impact concept as it applies to criminal records. Under the state law, we also have the same thing. And so the regulations really go into a lot of detail about criminal records issues, and they explain more specifically what is permissible for landlords to do and what is not permissible. So a few examples of this. The most simple one is that blanket bans are not acceptable. So you cannot have a policy that says, I'm not renting to anyone with a criminal record, because that is overbroad and it does not look at individual circumstances. So those are a no-no. It's in the regulations laid out. And then it also says that landlords need to consider mitigating circumstances. For example, if there's a reason that the conviction happened, that can be explained by something that would indicate that the person is actually going to make a fine tenant, then they have to consider that. They also have to give a written notice to the person who is applying for housing. I'm thinking of a scenario where someone has applied for housing, the landlord does a background check, and something comes up that's related to a criminal record. So the tenant has to get a written notice about that. And this is really important because unfortunately, a lot of the background check companies, I think people probably know this, but a lot of the background check companies don't actually do a very good job of checking if the person that they are flagging as having some bad history is the same person that's applying for housing. There's all kinds of horror stories of people having all these awful things come up on their record that have nothing to do with them, because it's actually sort of like a different middle name, or it's a different birth date, it's a completely different person, and they're being barred from housing for this criminal record that has nothing to do with them. So that written notice to the tenant or the prospective tenant gives them an opportunity to confirm, is this actually me, or provide any mitigating information. And these issues also bring up a lot of consumer protection laws, which I'm not going to talk about, but that's something also to explore if you're dealing with this type of situation. The criminal records section also talks about intentional discrimination. So it's not permissible for a housing provider to have a policy about people with criminal records with the intent of excluding people of color or any other protected group. Or making discriminatory statements, and then that's generally true. It's not permissible to make discriminatory statements saying, I'm not going to rent to people who are Black or whatever. And then finally, it also prohibits adverse actions based on arrest without a conviction. So there's all kinds of things. I've dealt with many cases where people had something bad happen to them in their housing, where the housing provider says, oh, you were arrested, so I'm going to evict you. No. So an arrest, there's no, we're innocent until proven guilty, and an arrest is not enough to terminate housing. Similarly, if someone has a juvenile adjudication or some kind of sealed conviction, that cannot be the basis for an adverse housing action. And in the regulations as well, it has definitions of housing practices that are very broad. So it's not just letting someone rent or deciding whether to evict them. It's also things like you can't sort of steer someone to the less desirable part of the development, or you can't sort of deny them other types of services or say, oh, you can't use the common area or different things like that. So it's very broad in terms of what is prohibited for discriminatory conduct. Okay, I'm gonna stop there. I see we already have some questions. Stephanie, do you wanna help me navigate the questions? Okay.
Oh, trying to get back to you. Okay. Hi.
Hi.
Thank you. That was really helpful. Let's see what we have. Does AB 1482 apply to a single family residence?
It's complicated. That's the answer there. So so I'm not sure if it's helpful to go back to maybe I can pop back to the slide. So sometimes, yes, it does, but not always. So a single family home, if you are renting a single family home from an individual human being and you are the only person renting, then it will not apply, because there's no corporate ownership and it's really only one tenant. So it will be exempt if it's a human being renting a single family home to a family. But there are a lot of circumstances where single family homes will actually be covered. For example, if there's corporate ownership, like a corporation like Blackstone owns the property, or if there's an LLC that owns the property, a limited liability company that owns the property, and one of the members of that LLC is a corporation, or if it's a single family home where it's kind of functioning as multifamily housing. For example, if separate bedrooms are rented to separate tenants, or if there's sort of another unit in the back that's being rented out separately. So it depends on those types of specifics. And what I've had to do, even though I have spent a tremendous amount of time with this law, when I get some kind of funky fact situation, I just have to look at the language, because it's a very detailed analysis that you have to do.
Okay, thank you. The next one is similar. What if the owners only live there part-time?
So, like I said, there are some circumstances where even if the owners live there all the time, it would still be covered. But several of the exceptions specify that there will be an exemption only if the owner's principal residence, if it's the owner's principal residence. So if we look here at the slide at the bottom left-hand corner, if, for example, there's a home where the tenant was renting one room and sharing a bathroom, but only the landlord is only living there part of the time, there would not be an exemption, because this specifies that it's the owner's principal residence.
Okay. Does a new adult need to join the lease in order to reset the clock on just cause timing, or does simply moving in trigger the reset even if they're living there as the guest of the first tenant?
It depends. I feel like I'm just going to say it depends for all of these questions. When you say guest, it suggests to me that it's short term. I think a lot of leases and tenancy agreements will say something about you can have a guest for up to 15 days or 30 days or something like that. A short term guest would definitely not trigger it. But if someone is moving in and they are, even if they're sort of going to move in for a long term, and I don't think that it would matter if they sign the lease. I think it just is going to depend on the facts. It depends on what you want the answer to be. And then you look at the facts that support that answer. Are they paying some of the rent? Is the landlord aware of them, and are they acting as another tenant? It depends. I'm sorry that that's such an unsatisfying answer. This is a very detailed statute. But at the same time, some of the exceptions don't have a lot of detail in them. So it can be a little bit hard to see how they apply in an individual circumstance.
Okay, next one, I don't know if it's a question for you or not, but it's, what have you found to be the best resource for thorough background checks on potential tenants?
I've only found bad ones. So I don't know how to answer every one that I have heard of. People talk to me when it's bad, when they're pulling up the wrong person. So I unfortunately do not have the golden background check answer. Yeah.
Besides tenant turnover, are there any scenarios where a landlord could raise rent twice in a 12-month period?
No, it is pretty clear about that. So the rent increases are limited to twice in a 12-month period. So as long as it's the same tenants, or at least one of the same tenants, that limitation is going to apply.
Okay. After a reasonable accommodation request is made and landlord or management denies it, this is not in the eviction context, what do you recommend for the tenant as next steps?
Yeah, great question. So the law, both the statute and the regulations specify that there's something required called an interactive process, and that means what it sounds like it means. So if a tenant asks for a reasonable accommodation and says, like, this is what I need to be able to use and enjoy my housing because of my disability, it is not acceptable for the landlord to just say no or say nothing, which happens a lot. Instead, it's required for there to be some kind of back and forth discussion, whether it be, you know, I can't grant that exception because it just totally changes the way I operate my business, but what about this? You know, there has to be some kind of back and forth. And I would encourage, Sadie, thank you for asking this question. I encourage you to check out the regulations because that actually goes into a lot of detail about this. Like what is an appropriate amount of time to wait before getting an answer, and talking more about what it means to have this interactive process of back and forth. But the next steps would be to ask for some conversation, ask for a meeting, ask for other approaches that would allow this person to use and enjoy their housing.
Thank you. What facts give rise to a violation of public health and safety or need to protect public health and safety in order to get a summons issued for unlawful detainer? So I guess this is
COVID question.
Yeah, snuck in a COVID question, John.
Yeah, I mean, I can say a few words about that. I actually talked with Stephanie before this training about whether we should try to talk about COVID as well, because it's at the top of everyone's brain right now, but there's just a lot to cover. So, so I can talk for a few moments about that. So in addition to many communities passing local protections saying that you can't be evicted for losing income as a result of COVID, there's also been some things happening at the state level. The governor has issued a series of orders which actually don't have a whole lot of practical import for unlawful detainers. But the thing that I think John is referring to here in this question is that the Judicial Council has issued emergency rules related to COVID. And what those emergency rules say, in part, is that no summons will issue an unlawful detainer unless there is a public health need for the summons, for the case to go forward. So what that means is if a landlord wants to evict a tenant during this time period, when we're in the state of emergency, they can file the complaint, but then the case stops there unless the landlord makes a showing of public health and safety. And then if the court finds on the record that there's a public health and safety need for the case to go forward, then a summons will issue, then the tenant can be served and the whole process goes forward in court. And in answer to this question, it's just totally not specified. So I've tried to talk with, I've talked with different people who are dealing with these types of cases. And I think maybe an example of what this would mean is if, you know, a tenant is going around brandishing a gun and shooting like into their ceiling or something, like they're causing an immediate risk to health and safety. That would be the kind of thing that I could imagine, you know, there being a showing made that this tenant needs to be removed from the property because they're causing a risk to other people. It doesn't mean, for example, I mean, none of this is specified. You just have to argue it, but it doesn't mean something like, you know, the tenant isn't cleaning their house properly, or they're, you know, something more minor like that is not a public health and safety need. But the rule really doesn't specify. All it says is the public health and safety thing. So I think that different courts are treating it really differently, procedurally and substantively, in terms of like how they're handling those cases.
Great, thank you. Renting a single family home to 5 non-related students, would that be covered under 1482?
It would be, and because this is that situation that I was mentioning where it's kind of operating more like a multifamily, where there's like separate tenants in each room. So yes, it would be covered. No exemption there.
Okay, does non-payment of rent due to COVID still amount to just cause, or are there special provisions?
So 1482, because it was passed before COVID, now it feels like COVID's been going on forever, right? Time is just like stretching out. So this law does not say anything about COVID. And right now, my colleagues in Sacramento and many others are working to make a law that would talk about non-payment of rent from COVID and try to address that issue. But that is still in process. Those discussions are still going on in the Senate and the Assembly and the governor's office. So right now, non-payment of rent due to COVID is still just cause, because this law just doesn't speak to that at all. But hopefully very soon we are going to have legislation which is going to address that and is going to prevent the otherwise tidal wave of evictions that's going to happen when the courts reopen. So a lot of people are working on that, but it is not solved yet.
Okay, related to criminal background inquiry, if a landlord discovered a criminal conviction for a potential tenant, what type of written notice is required required? Would a letter suffice? And then what would you suggest in terms of how to allow the potential tenant to offer evidence of mitigation or an explanation?
So I don't know the specifics off the top of my head from the consumer laws, so I can't really speak to that. But in general, you should provide a copy to the tenant of the exact thing that the landlord received. So provide a copy, that shows them where the information came from, the name of the background check company, and obviously that would also have the conviction information and the name. And so they basically just need to have all of the information that the landlord got. So a letter, I'm not sure what that looks like, but just providing a copy of the thing that the landlord got would be the best way to ensure that all the information is there. And there's not really a specific procedure provided in the regulations about offering mitigation or explanation, but allowing the tenant to submit things in writing or in person, just having a flexible process that allows the person to provide information about their background. And I also want to flag that just having a conviction, saying, even if someone does have a conviction, just having a conviction doesn't mean that it's okay to deny them housing. For example, like someone has a conviction for shoplifting a loaf of bread or something. That does not show that you can't meet the conditions of tenancy. Maybe someone was experiencing hunger and they took some bread. So there's a lot that goes into that inquiry, but a conviction alone is not enough to sort of address all the fair housing concerns.
Okay, 1 house, 5 tenants, 4 leaving at the end of 1 year. Can you evict the last tenant without further notice?
No. It sounds like if there's still a tenant there, then all the same things would, I think I would need more information. But in general, when you evict someone, you need to give them a notice. And depending on all the detailed stuff that we've talked about, what that notice looks like would be different. But I can't really tell from those facts exactly, but evicting without notice is a no-no.
What about if renting to 1 student and that 1 student subleases the bedrooms? So
I'm not sure what the question is here.
I think maybe would 1482 apply if there's multiple tenants, but the landlord's only renting to 1 student, and then the student subleases to more students.
This is going to be a fact, like what does that look like? Is there a lease agreement? Is this a single family home? I just have more questions. I don't know from those facts what the answer is to that one.
Single family home. It sounds similar to the other one, depending on whether the landlord knew of whether there were multiple tenants. And
yeah.
When will we be able to file UD complaints again?
Well, so the CARES Act, because wasn't planning to talk about COVID, I kind of didn't go into this, but in addition to the state protections that we now have, the CARES Act is federal legislation that says that for covered properties, you cannot even file a complaint. And that, this is like a whole nother thing, but the CARES Act applies to a lot of different types of housing, including those that are federally subsidized in some way or have a federal loan or some kind of federal link. So that's a whole nother thing. You can kind of Google it and find lists of them on there. In those cases, you cannot currently file a complaint if you're covered by the CARES Act. The CARES Act is set to expire, but then Congress is looking at extending it. I'm not sure what's going to happen. But under state law, if you are not covered by the CARES Act, you can currently file a UD complaint, but the case won't go forward because of the Judicial Council rule. And the Judicial Council rule does not have an expiration date. It says that it will expire 90 days after the state of emergency is over. Was that a complicated enough answer for you? This is all, that's the answer. There's a lot.
I know, and because we didn't want to be too greedy and have you have to talk to us about COVID again, Sadie and I are going to be talking through the Women Lawyers Association about the COVID changes for landlord tenant on August 4th.
Oh, so great.
Yeah. So thank you so much. I think we got through, it's 1 o'clock and it looks like got through all the questions. So perfect timing. Thank you so much, Madeline, for joining us. And we will be logging out, but thanks everybody for joining us and hope to see you next month.
Thank you so much, Stephanie. Thank you,
Thank
Nicole.
you.
Thanks, everyone.